Hello everyone, today we'll deal with what is search warrant and some important points regarding it under the CrPC. So now let's start the video. A search warrant is a written authority given to a police officer or other person by a competent magistrate or a court for the search of any place, either generally or for specified things or documents or for persons wrongfully detained. So I've simplified the definition as such. A competent magistrate or a court gives written authority to whom? To police officer, or if the police officer is not available, to some other person. For what? For search of places, things, documents or persons wrongfully detained. So section 93 of the CrPC deals with search warrant when it is issued. So clause 1 deals where any court has reason to believe that a person to whom summons or order under section 91 or a requisition under subsection 1 of section 92 has been or might be addressed will not or would not produce the document or thing as required by such summons or requisition. So a summons or any order has been issued under section 91 or a requisition has been made under section 92. It has been addressed or might be addressed, and the court has reason to believe that he would not produce such document or thing. Then the court may issue a search warrant. Reason to believe here means sufficient cause to believe. In other words, the magistrate or court must himself or itself be satisfied that there is necessity for the search warrant to be issued, otherwise the thing would not be produced. Secondly, where such document or thing is not known to the court to be in the possession of any person, or where the court considers that for the purposes of any inquiry or trial or other proceeding under this code will be served by a general search or inspection, then also court may issue a search warrant. The word may in this section means it confers discretion on the court to issue a search warrant. The court is not bound to issue a search warrant whenever it is asked for. A general search here means a roving inquiry for the purpose of discovering documents or things which might involve persons in criminal liability, but not in respect of any specific documents or things which are considered necessary for the purpose of any proceedings under this code. Here the general search or inspection has been allowed in case of inquiry or trial, but not in case of investigation. Here investigation word has been omitted. The other 2 points in the section, subsection 2 deals, court may specify the particular part or particular place to be searched. Also, person directed shall then search on or inspect such specification. Third subsection, only the district magistrate or the chief judicial magistrate have the authority to grant a search warrant for any parcel or document in custody of any postal or telegraph authority and no other magistrate. The phrase for the purposes of in section 93 1c not to be considered as during pendency of. The stage at which a warrant for general search is issued may be prior to the initiation of any proceeding under the code by way of inquiry or trial. Also, the court or magistrate should be reasonably satisfied that the search is likely to be a link in the chain which in the normal course will lead to an inquiry or trial under the code if the expected material is found on the search and that there are reasonable grounds for such expectation. Whether a search warrant infringes fundamental right? No, it's a not violation of Article 19(1)(f). It's only a temporary interference or invasion of the right. Whether it is for accused, whether a search warrant can be issued against the accused? No, it is not issued against the accused. Only a general search is permissible in a case decided, and it's not violative of Article 20 Clause 3 of the Constitution. Also, recording of reasons is not mandatory in case of granting a search warrant. It may be recorded so that a superior court is enabled to examine on what grounds it was made by the subordinate court. Another point, search in violation of the provisions of this code does not vitiate an investigation. The evidence obtained by an illegal search is admissible. It was decided in the case of Indu Bhushan versus State. So what are the remedies available for illegal search warrant? A writ under Article 226 of the Constitution and a return of the documents seized. These are all about section 93 CRPC. Hope you all like it the video.